it can be a chicken and egg kind of dilemma
Yeah.
in that retaining counsel will want to know if they're doing due diligence about the number of depositions that you've given, your trial testimony, and if you're just starting out, you may not have any,
Yeah.
and so that becomes and how do I get it? It's like an
Yeah.
attorney who's trying to get trial experience. That's okay. We won't put you on a timer.
It's no secret that expert witnesses are a treasure trove of information, analysis, and insights. And this is not limited to simplifying complicated concepts for the judge and the jury. In fact, experienced expert witnesses can also help unlock the mysteries of this profession for greenhorns who have the right credentials but may not have the experience of working as an expert. In the first season of On the Stand, we aim to tap into the experience of some of the best known expert witnesses and ask them to spill the beans on what has or has not worked for them. In today's episode, we are joined by insurance claims expert Kevin Quinley. Kevin is one of the best known experts in the insurance claims industry and has authored more than 700 published articles, along with 10 books on claims and risk management. When it comes to being an expert witness, he has served as one in more than 140 cases nationwide, including more than 40 depositions and 12 trial testimonies in federal as well as state courts. And last, but definitely not the least, what makes him a great expert is his balanced caseload across the plaintiff and the defense bar. So if you're an insurance professional or someone else looking to learn the tricks of the trade, that is expert witnessing, make sure you listen to the whole interview and implement the tips that we are about to receive today from Kevin. Kevin, welcome to the show.
Thank you, and thank you for that kind introduction.
So let's start by hearing the origin story of Kevin Quinley. How did you get your first referral as an expert witness, and what made you stay?
I never planned to be an expert witness. I did not map that out as a career path. The genesis came in the early 2000s when I was in a corporate role as a senior VP of claims with an insurance company. And because I had sort of a parallel career as a business writer, I had been writing and having published a lot of articles. And because I was speaking at conferences and seminars, this was long before Zoom, everything was done in person. I think because of my industry visibility, I started receiving unsolicited phone calls from law firms around the country interested in hiring me as an expert witness. Most of those I had to decline because I had a very demanding corporate job at the time, but a few I took on sort of a moonlighting basis, working on them on weekends and after hours. And I enjoyed it, although I was, feeling my way through as a neophyte, as an expert witness. And that continued from the early 2000s and for about a decade. I was highly selective about the amount of cases I could take on. It finally reached a point where, my wife had been urging me. She said, "You're turning away so many cases. Would you ever consider doing this full time and leaving the corporate womb?" I said, no, I could never do that. But in the fullness of time, there came a point around 2011, after 30 years in corporate roles, I took a deep breath and I said, I'm gonna do this. I voluntarily left a very nice corporate job with benefits and retirement plans and stock options, etc., where mommy, the corporation, took care of me, and took a deep breath and said, okay, I'm gonna try this to see if I can do this full time. I had a couple of open cases at the time, and then within about 3 weeks of making this decision, which was terrifying for me, I got my first new case, And it really kind of snowballed from there. I did outreach with law firms. And so I left a corporate role in November of 2011. And the next day I formed Quinley Risk Associates. So there was no grand design, and the rest is history. I've been doing it. This November will mark my 12th year doing it full
Wow.
time, nothing but, and I've never looked back. It was scary at the first. My wife had more faith in me than I had in myself because
Mhm.
she said, I always knew you could do it. But it was various aspects of my background, the writing, the speaking, um, the obviously the subject matter knowledge, and even going
Mhm.
back to my high school and college days, I was on the debating team. I was for there about 6 years between high school and college. I was extremely focused on competitive debate, represented my college for 2 different years at the national championships. And although I'm not in a debate role, it gave me research skills, I think
Yeah.
analytical skills, in a somewhat adversarial environment with a slightly different set of rules. All of these sort of came together, I think, and help position me into the role that I've got now. So I've never looked back. I am not retired. I've never retired. Unlike a lot of experts in my role, they retire from a corporate job, which is great. They got a pension. That's great. And they do this because it's sort of a extra cherry on top revenue
Mhm.
stream. That's not me. I went straight one day in a corporate role and into this role.
Wow, that's really a story. I mean, I like how everything really came together and led you to the world of expert witnessing, and you've done such a great job for so many years. So let me ask you, what does a typical work day look like when you're working on one or multiple active cases? And especially, what are the most rewarding and the most challenging aspects of the job?
Well, the work days can vary, but I'm going to outline an overall structure. I try to observe what I call fixed schedule productivity in terms of
Mhm.
I try to consistently start work at a certain time of day, usually around 10 in the morning, and knock off by 4 p.m. in the afternoon with breaks for lunch and such,
Mhm.
and to have a hard shutdown. Now that, the best laid plans. Um, but typically it's a blend of a number of functions, Ashish. Usually there's a good bit of reading and analysis of case materials, writing. There's always a disclosure or a Rule 26 report that may be
Yeah.
due. Another big bucket or category is preparation for testimony, whether it's deposition testimony or trial testimony. I put a lot of time in
Mhm.
in in trying to prepare for that. Phone conferences with counsel on existing cases to talk about strategy, to talk about issues. Phone conferences with attorneys on prospective cases. I try to prioritize those because that's key to business development.
Yeah.
A lot of times, you want to be prompt in responding, and I will scrap my best laid plans for the day
Mhm.
in order to accommodate the needs of an attorney. Now, I may or may not take the case. That's another
Yeah.
call. Another call with peers and colleagues in terms of networking. I'm part of a organization of insurance experts nationwide, and I just finished up a 2-year term as president of that
Yeah.
organization. But that came with a lot of administrative overhead, and
Mhm.
it was an honor to fill that role. I'm still on the board as the immediate past president, or I'll get calls from other experts, referral opportunities, or maybe I can refer cases to them. Business development outreach is another bucket in terms of
Mhm.
reaching out to attorneys I haven't heard from for a while. Thought leadership, I write articles, I have a website, I write a blog, I submit articles to professional organizations and trade journals. I try to attend webinars like the one that you were a panelist on a few days ago to try to stay current, both in terms of the subject matter content of my specialty, which is insurance claims and the general legal category of bad faith. Although I'm not an attorney and do not opine on bad faith, but claim practices and standards. And sometimes I have to travel. Sometimes, giving testimony
Mhm.
often by Zoom. That's a technological refinement that we can talk about later. And if the case doesn't settle, 90% plus resolve, either by summary judgment or settlement at some stage, many times before I have to give a deposition. But in the fourth quarter of this year, I've got a number of cases set for trial. So I'm going to be, on a plane, traveling and conferencing, strategizing with attorneys. Then there are occasional fire drills where deadlines loom, and on very short notice, you have to tack and zig and zag. That's one of the challenges of this job you mentioned, and that is the deadline driven nature of it. I try to keep up with professional reading in terms of public trade publications that I subscribe to, or listservs or LinkedIn groups. I moderate a extra contractual and bad faith subject matter group on LinkedIn. I don't spend a whole lot of time on LinkedIn. There's a lot of good content generated by attorneys about the law practice, not so much about the substantive area of law. But again, I'm not an attorney, but very, very good content that is highly applicable to non-attorneys, such as solopreneurs, somebody like me, a solo practitioner who has a similar knowledge work kind of job. It's in a slightly different realm. So that's, sort of a grab bag overview of what a day in the life is. I try to begin at a certain time. I try to knock off at a certain time, and to have a shutdown routine. But again, the best laid plans. Some days are longer, some days are shorter, and sometimes these days blend into the weekends as well, depending upon how many projects I've got going on, what deadlines are coming on. If I do a report that needs substantial revisions, substantively or otherwise, formatting wise, you make do.
Wow, like you're clearly packing a lot in your work day. I mean, and it's really amazing that you've been doing it for so long and you've come such a long way. And and over the years, you've clearly also seen like the advent of the computer, the technology, the internet, and now artificial intelligence, and how these things have impacted the justice system. So what has your assessment been on the impact of technology on the role that you play as an expert witness?
Well, certainly an obvious example would be COVID and the ubiquity of Zoom as a tool to obviate the need for a lot of travel and a lot of in-person. I know there are pros and cons, but it has certainly sort of revolutionized depositions. It's rare, for example, nowadays, where I give a deposition in person. Although I'm able to do that and have done that, but the default mode is doing it by Zoom, and I like that. I'm open to either one. In fact, I even had one trial a couple of years ago in Louisiana where I testified by Zoom or a video rather than travel to Monroe, Louisiana. So that's made things more efficient in some ways. You can argue about, whether quality-wise there are any drawbacks. So that's certainly one thing. This is not necessarily a new development, but speech-to-text software, which I've been a early adopter on from the early 2000s. Most of my writing is near a keyboard, but not necessarily through a keyboard. What I mean by that is that I open up my Word program and I will dictate ideas and thoughts. And I'm very comfortable. Having done this now for decades, I'm comfortable doing that. Even back in the 1970s, when I was a street claims adjuster, we had these large cassettes, and we would dictate reports to clients on accident cases and claims. So, and then of course, you've got to go back and edit that, which you would have to do even if you typed it out on the keyboard. But you can typically speak much faster than I'm not a
Yeah.
fast typist. So, if you can speak 140 words a minute, there's no way I could type 140 words a minute. Speech to text software, AI, with the emergence of Chat GPT
Yeah.
and generative artificial intelligence. We'll have to see how that affects expert witnessing. The flip side is this:
Yeah.
I recently listened to a podcast by an attorney. He has a podcast called 10,000 Depositions Later. He's a Florida-based attorney. He's an employment attorney, I think often on the plaintiff employee side. And he was talking about how he was using it. And he would like put in a prompt such as, give me 50 questions to ask of a corporate
Yeah.
safety officer, or give me 30 questions to ask on topic A. And in a couple of seconds, he or she, depending upon who the attorney is, would have an outline of deposition questions. So that's on their end, and similarly, I suppose expert witnesses could also use this as well. Or I haven't done this yet, but taking the report of an opposing expert and cutting and pasting it into the AI and asking them to analyze it in terms of logical weaknesses in the argument, or to do that for one's own draft, to help bulletproof one's own report. Again, I've not used that yet, but I can see where generative AI would not replace, but augment the expert witness's ability to quality control their own written work product. I've even heard of, I haven't figured out how to do this, inputting deposition transcripts into generative AI and having it either summarize, cut down on time, or analyze it for inconsistencies, logical flaws, things like that. So we're just scratching the surface on AI, but those are some of the and transcription tools for conversations like this. Those are, some are low tech and some are high tech. I still use legal pads. In preparing for depositions, I will use flashcards. I mean, I did it in high school, I did it in college, I did it in grad school, and now I'll have file drawers of 4x6 cards where I try to take the facts about the case. I don't try to memorize dates, but there's typically key people and terms germane to each case, so that before a deposition or a trial, and I will drill on those cards. So I prepare for it like it is the most important exam I've ever taken, and in a way it is, because it's an oral examination, and unlike a examination in college or defending a thesis in graduate school, you've got a hostile. These people are not rooting for you to succeed, but I try to have those, as well as substantive questions. Every case has strengths, and every case has weaknesses, and trying to anticipate the weaknesses questions and formulate and if you will, prepare to address those as best I can.
No, it's pretty amazing. And I think I completely agree with you that we are just scratching the surface with AI, and all the use cases that you have talked about, they will become more prevalent once the privacy concerns and the hallucination concerns are taken care of. It's already getting better, and more specialized tools are coming into the market. So we are clearly interesting times lie ahead of us when it comes to technology and how AI is going to impact, be it lawyering, expert witnessing. And like they've been saying in the legal domain, that AI will not replace lawyers, but a lawyer using AI will replace a lawyer not using AI. So I think the same analogy can be, extrapolated to experts as well. That like an expert witness using AI will have an advantage over the one who's not using and making use of these tools.
I agree. And as well as the business application,
Yeah.
if there are certain recurring types of communication, whether it's follow up and collecting on a
Oh yeah.
bill, whether it's whether it's a cover letter with an engagement agreement, whether it's a note to appreciate and thank a client for thinking of you for a
Yeah.
referral. There are a number of recurring types of business correspondence, I would say, that are fairly consistent. You can always customize them and should customize them to
Yeah.
the case, but it will free up the expert, just like it
Oh
could
yeah.
free up an attorney, to devote their time to higher level, more value
Yeah.
additive activities and streamline some of the more uh, crucial but repetitive or more rote type of there's the art of expert witnessing and there's the business of expert witnessing.
Yeah.
And to be effective, I think you need to be proficient in both.
Yeah. So again, I mean, talking about the business of expert witnessing. So what has technology, like how has technology impacted that? Do you think it's easier today to get more referrals, or it's more difficult than it was a decade ago?
That is tough to address.
Mm-hmm.
Having been doing it now full time for about 12 years, I wouldn't say it's easy. It's so episodic. I
Mm-hmm.
see it's like an EKG strip, with the
Yeah.
with the crests and valleys.
Mm-hmm.
And sometimes there's no telling. So I have the advantage, I guess, the blessing of seeing an uptick. Because most cases I have to decline either because they're
Mm-hmm.
really not in my swim lane.
Yeah.
They're not in my core area of expertise. I think that's important to
That's really
know your
important.
limitations,
Yeah.
to know where you are and are not, as tempting as it may be sometimes to take a case at the outer bounds, out of periphery of your expertise. Um, in terms of if I was a new expert witness, and I know some who are trying to break in, it
Mm-hmm.
can be difficult. It can be a chicken and egg kind of dilemma
Yeah.
in that retaining counsel will want to know if they're doing due diligence about the number of depositions that you've given, your trial testimony, and if you're just starting out, you may not have any,
Yeah.
and so that becomes and how do I get it? It's like an
Yeah.
attorney who's trying to get trial experience.
Yeah.
They're 7, 8, 9 years into being an attorney, and they've not had a chance to try a case. And so the client wants to, if they're going to trial, they want to entrust it to somebody who's got some seasoning in that arena
Mm-hmm.
and are loath to have you be the first one to test case. But I
Yeah.
guess as in any other realm, surgeons have the same thing.
Yeah.
If you're the patient, you want to be operated on by the person who's doing the first time they're doing the bypass or placing the stent, or somebody more seasoned. So it's a professional quandary.
Mm-hmm.
I think it's hard, not insurmountable. One thing that helped me, Ashish, is that in my corporate role, occasionally I had given depositions as a fact witness, as like
Mm-hmm.
either a 30B6 witness. The companies I work for
Yeah.
did not get sued much. But if you're in an insurance company,
Yeah.
whether it's has merit or not, they're going to get sued. And
Right.
so there were cases where sometimes it was disputes between excess carriers, and I was a primary carrier claims manager. So I had a half a dozen, 6 to 8 to 9 depositions. So I had some deposition experience even before I became an expert witness, albeit it was as a fact witness or 30B6 corporate representative, not in the capacity as an expert. So I had some frame of reference. That's a
Mm-hmm.
long-winded answer to say I think it's difficult but not insurmountable. And if you have experience from your corporate role that you can analogize to an expert, um, and you have you're building your record, whether it's in publications as a thought leader, in terms of a blog, and developing top of mind awareness, and just having a systematic approach to approaching law firms and attorneys that you knew in a prior life. Um, those are some of the components, I think, of trying to break in. It's not easy. Mine was not easy, but the glide path was facilitated because I got a running start that paralleled the twilight of my corporate career. Had a lot of attorney contacts, had published a ton of stuff, never with the idea of parlaying that into being an expert witness, writing books with never planning on parlaying that, but it all kind of came together.
Yeah, I think it also, like helps when, let's assume an attorney is looking for an expert like you, and they may not have, like they may not know about you. So if you have published, and if there are articles and blog posts, and you have like maybe networked on LinkedIn and commented there, it all comes up in searches. So the more, like, even if you don't have, like, one doesn't have the experience as an expert, but if they are regularly contributing to the discussion and putting content out there, I think that really works to their advantage when somebody is searching for an expert like you. So maybe thinking from an attorney's point of view that, okay, what kind of an attorney would look for an expert like me, and what kind of searches would they run? And then if you are creating content around that, that may really help a greenhorn expert in getting started in the business.
I agree. The visibility, although I think it can be overdone with social media, but because you can go down a lot of rabbit holes, and before you know it, a lot of your workday. But I agree, value-added content. I'm a big believer in content marketing, which is not, beating your chest, I'm great, but putting out there, whether it's blogs or articles on LinkedIn or other mediums such as YouTube, that that give practical knowledge to people. I'm a big believer, you got to give before you get. You got to put out there, and it can't be fluff. There's an attorney that, Jay Harrington is very prominent on LinkedIn. He was a practicing attorney, but now he coaches attorneys on business development, and like he has a discipline of posting every day advice to attorneys on how to build their practices, and a lot of that stuff is applicable again to non-legal realms. That's one reason I like him, but that's like water on stone, and he's written books, and he does articles, and then he does coaching of attorneys. That's what he does now. So I think social media could be like an intellectual drug, the intellectual crack, in terms it can be addicting and a huge time suck. I think it's part of. The other, not to overlook the obvious, I think that once you get a case, once you get that first assignment, is to just do a kick-ass job on it. Meet the deadlines, do quality work in terms of your written work product. If you are called to testify, being extremely prepared, being very easy to work with the law firm at a reasonable cost, and hope thereby that you will get word of mouth referral, that at the end of that case, regardless of the outcome, which the expert cannot control, that's a hard thing to get around at times. You control what you can. You're a bit player in a larger drama. But to do such a good job for that attorney and that law firm that they will remember you, and when they get a call from a colleague or from another firm saying, I have a case involving X, do you know what, an expert, they think of you with the top of mind awareness. But you can use, I think, a blended approach, thought leadership, content generation, social media presence, doing a great job, direct one-on-one follow-up, are all components that help generate business. But sometimes you got to plant those seeds. It's a, you know,
Oh yeah.
and big trees grow from little seeds, but sometimes it takes months or years. It's not instant gratification. You know, you press these buttons and the cases just start coming. It doesn't, you dig your well before you're thirsty. And the things that we've talked about are all part of planting seeds and digging that well.
Yeah, like the saying, no overnight success is really overnight. They have put in the long years of hard work.
Overnight successes sometimes take a decade to reach that stage.
Exactly. So and all of this is very high pressure work, you know, like and this is something that we keep talking about across domains, like lawyers and litigation support professionals, like experts. They're some of the most burnt out folks that way. So as an as an expert, like some work full time as an expert witness, but some also have a primary profession and they are working on the side on high pressure, high stakes litigation. So how do you manage the pressure which comes in working in this industry? Like, what are your tips, and like, you know, like, and any anecdotes where you may have had like a high pressure situation that you handled?
Well, you're right. I mean, you read, if you're on LinkedIn, you see how work-life balance among the legal profession and burnout, especially the so-called big law practitioners, but not exclusive to them. And it's not exclusive to lawyers, whether they're big law, medium, or small firm. So I think that is one key aspect of longevity and success in the role of an expert witness, recognizing and being able to manage the stress, because it is very stressful. It is deadline driven. It is in an adversarial context. You have extremely smart people on the other side who are spending weeks or more preparing to make you look foolish, inconsistent, in a negative light. You feel pressure as an expert witness. So I don't claim to have the answer or have mastered this. A couple of things that work for me. Number one is understanding that the word no is a complete sentence. What I mean by there used to be some Clint Eastwood movies, the Dirty Harry movies, where he said, quote, "A man's got to know his limitations." And you can, whether it's a man or a woman. And I think that's very, very key in terms of before you take on or say yes to a new engagement, as tempting as it may be from a financial maximization standpoint, you have to pause and think of the entire spectrum of other commitments that you've got, particularly other cases, how active or dormant those cases are, personal milestones or commitments that you have. You got a family, you got a spouse, you have kids, vacation plans, other events that you need to work around, and whether or not the trade-off is worth it, and being willing, having the courage, even if it's a very attractive opportunity, to say no thanks. Example, a couple of years ago, I got a phone call the Wednesday before Thanksgiving, big holiday here in the US. And it was from an attorney in Philadelphia with a firm that does a ton of the kind of work that I do. I knew him, I liked him, I knew it could be a great source of business. He's calling me about a new assignment. And we talk about it. And of course, one of the things I've learned to ask is, what is the deadline for the work product? Well, the deadline was the Monday after Thanksgiving. So essentially, saying yes to this engagement would have meant that in lieu of spending most of that Thanksgiving holiday and weekend with my family, I would have to be heads down, intensely working on this case. And so it was a no-brainer to me. I thanked him profusely, but I had to politely decline it. But, you know, in another time of life, I've learned the hard way. One of my first engagements was in December, and I didn't think to ask how voluminous are the materials that the expert needs to review. This was before the digitization of a lot of the content. So just before Christmas, I got a couple of banker's boxes delivered to my house, and I spent my Christmas vacation, quote unquote, using air quotes, slaving over this Rule 26 report. It was a federal case, so that I could have it ready by early January. And I vowed at that point to try to never put myself in that case again. So I always ask, what is the deadline for the written work product? And saying, it's like the old Nancy Reagan slogan from the drug wars: just say no. There's a nice way to say no.
Yeah.
Hopefully they respect that, and they will not, blacklist you from future assignments. I think most of them do respect that, but not taking on more work where you say yes in haste and you repent at leisure. Although it's not leisure, you repent and ask yourself, did I do that because I'm experts are professional jugglers. Okay, there are a lot of balls in the air, but if you can only juggle 3 balls and you accept 2 more balls and 3 more balls, now you got 5 or 6. One of those balls is going to drop. Either the work product will degrade, or something very important in your personal life will degrade. So that's one thing, just having a sense and not making a quick decision. And another thing I will do sometimes is to say, send me a copy of the complaint, send me some preliminary materials, give me 24 hours to look it over, look at the entire spectrum of my existing commitments, and I will promise to get back to you within 24 hours to let you know if I think I have the bandwidth to take this on. Because if I cannot do a quality job, as agonizing as it is, I would rather say no and no thanks now than to get into the project and find out that I have to cut corners on quality. I can't do a quality job. Another aspect is just that fixed schedule productivity, where you say, these are going to be my work hours from X to Y, whatever it happens to be. And I'm not going to work unless there's something really extraordinary. And that happens. I'm not going to work beyond that. I'm going to have a hard shutdown. And some call it an end of day ritual. You close the laptop, you shut down the computer, you set it aside, and you say, I'm done for the day in terms of work. I'm not working nights if I can avoid it. Again, sometimes you do. I'm not working weekends if I can avoid it. Again, sometimes you have to. There are exceptions, but having the discipline to cut it off, to take breaks, especially with knowledge work, I think, intensely focused work. And that means get away from the computer. If you can go outside, walk around, if you can spend some time each day outdoors in nature, whether it's a park, whether it's a beach, whether it's by a river, if you're a body of water. I've got 2 dogs, so I can walk the dog, or I take take mini breaks to clear your mind and get outside. Those are all techniques, I would say, in terms of trying to manage the stress and realize that you have the autonomy to calibrate how stressful it is, and to look at the positives. There's a saying that pressure is a privilege. There's a certain, you're under stress and you have this pressure because you have subject matter knowledge that is needed and desired, but every good thing in moderation. And so I think it's just really important for people not to overreach and overextend in terms of their own self-delusion about how much work they can take on at one time. But it's not always easy to calibrate, because it's not. The first half of this year was the most intense, busy time since I've been doing it full time, because of just the combination of deposition dates and trial dates and report deadlines, to where between January and the end of May, I was just working in the red needle zone. And I said to myself, boy, do I really want to perpetuate this lifestyle? Is this what I want to do? I've been doing it for close to 11 years. And, if somebody says, true wealth is discretionary time. And as an expert witness, if you're in demand, which is a privilege, then you may not have a lot of discretionary time. You get to a season of life where you don't know how much time you got left. And you got to ask yourself those bigger life questions of that limited amount of time, which I don't know how much I've left. Is this the way I want to spend it? Now, having said that, once that roughly 6 month period ended, the EKG kind of fell off a cliff. And for about a month there, I found myself with not a whole lot billable to do. And so but then I could focus more on thought leadership and doing some articles and stepping back and taking a look at my practice. But the one challenge of expert witness work is not just being able to calibrate or titrate your case volume. In a perfect world, you could, but it's not like once you finish a bunch of cases, okay, I'm going to take this other one off the shelf. Have a number of cases, but they're just dormant. They're on appeal. They're awaiting trial dates. They're in some state of suspended animation. From my standpoint, they're not closed, but they're not active, and there's nothing billable that I need to do at the time. And just like a law firm, even if you're a solo expert witness, you're a business. You have to generate income just like a law firm, and you generate income just like a law firm by doing billable work. So I may have strayed from your question, but those are some of the ways in terms of looking at your health and investing in your health daily. No matter how important your job as an expert witness is or profession, doing a daily habit of investing in your health, because without that is the platform for everything else. If you don't have your health, you don't have the mental clarity or the physical stamina to stand up to the rigors. It's mental and it's physical at times.
Oh yeah, it is.
You're in a 7-8 hour deposition. It's a mental and physical test, if you will. If you don't have that covered, not only will your work suffer, but that's the platform, that's the foundation for everything. But since it's not monetizable, it's very easy it's one of those urgent but not always important things until you have a health crisis that reminds you. At that point, you may be stuck with a condition that's too late to remediate. But daily investments in your health, in your exercise, in your fitness, in being physically active. You're in your head a lot as an expert witness. You're analyzing. You're up here between your ears. But what's important is the rest of the body, making sure that the rest of the body gets exercise, gets exposure to the outdoors and to nature. And I think that all sorts of studies saying that is key to mental health. That certainly came into play during COVID.
No, definitely. And so thank you so much, Kevin, for your time today. I really had a great time, and I really think this was really helpful. I mean, we keep seeing content on how to get more business, but how to manage, like once you get the business, how to last for a long, long time, how to continue getting business is something that we don't see people talk about a lot. So from that perspective as well, I think anybody who listens to this conversation will really benefit. I personally had a great time, and even though I'm not an expert witness myself, the last section where you talked about, that managing pressure and creating a work-life balance, I think those are really key takeaways for me as well. And thank you to everyone who listened into the episode. Let me ask you one last question, Kevin. Is there a question that I didn't ask, but you would have liked me to ask? Anything that you'd like to add?
I would just say, in terms of the advocacy role of an expert witness is a delicate balance. If you find yourself accepting a case and then you identify areas that trouble you about a case, I think it's very important to make sure you always want to be on the winning side, with the side that engages you. But I think it's important. the question would be, how do you reconcile the desire to win versus the aim of being objective as an expert witness? And it's very easy to have those roles become mixed. And your role as an expert witness is simply to give your opinion. You're an advocate for your opinion versus being advocate for the plaintiff or the defendant, and to maintain your objectivity and to be willing, with retaining counsel, to play devil's advocate, or not to play devil's advocate, to be devil's advocate in terms of candidly, by phone, not saying necessarily in an email or report, but saying, having the courage, this is the person paying you, but you can be a little more objective and to say to them, here's some problems that I see with the case. And I can't change those. I'm an expert. I'm not a magician. I can't make them go away. And knowing when to concede, to give ground, when to yield ground when you must, to maintain your credibility, and on what hills to put your spear in the ground and battle on. So I guess it's sort of a variation of groupthink, where you start to identify with the trial team, but you're not on the trial team. You're not one of the attorneys. Your job is to give an objective opinion. Now, you hope that opinion assists the party that hired you, but some may and may not. Let the chips fall where they may, but to maintain your own credibility and not succumb to groupthink, I think that's a key thing for experts to be mindful of. You want to be accommodating as an expert. They're your client, but sometimes your role as a client is to give them news that they may not want to hear. But I think that most attorneys, to give them credit, appreciate that. Or maybe they can set some context and cause you to rethink that. Or maybe if they're good, they recognize that every case has weaknesses. You're not there as a cheerleader. You're not there as to advocate for any one side or the other. You're there to advocate for your opinion, and if it helps the client, all the better. If it doesn't, well, that's not your problem. You're dealing with the facts as given.
So, for anybody who would like to follow up with you or get in touch with you, what's the best way to contact you?
Great question. Thank you. My website is kevinquinley.com. That's my complete name, www.kevinquinley.com. Or alternately, and it'll take you to the same site, Claims Coach. That's claims, plural, coach.com. Or reach me at claimscoach@gmail.com.
Pretty sure you'll be getting a few queries and questions from attorneys for sure, but also from experts who may want your guidance. Thank you so much for your time today, Kevin, and I really appreciate you doing this.
Thank you. It's been fun. The time has flown by. I appreciate your time as well. Thank you, Ashish.
Thank you. And thank you to everyone who listened in. We'll see you in the next one with another expert discussing another interesting aspect of the law, practice, and business of expert witness testimony. You are listening to On the Stand with Ashish Arun.